All right, we'll be with you shortly. Mr. Brignoli, are you representing the first case? Let me grab my docket here.
What's that? I have Mr. Harris, Gerald Harris.
And you're ready to go, or did you need a breakout room?
No, we're ready to go.
Okay, super. Thanks so much. And hi, Ms. Asion. What case are you here on?
Timothy Mikovits. He's a sentencing.
Okay, and I don't. All right, and I don't see him, but maybe I don't have a great view here. Let's see.
I don't believe he's on yet. I can't see him either.
Okay. All right, sounds good. Thanks. We'll be out shortly.
Thank you.
You're welcome. Thank you. Oops, wait a minute, I want my water. Thank you.
Okay, see ya.
Right. Ms. Casties?
Yes.
Hello.
Hi.
Hey, I just, I'm trying to get things checked in for the landlord-tenant cases, and I don't see them in OnBase.
All right, I'll check with Cindy.
Sure.
Okay,
Thank you.
you're welcome.
He'll be right out, everyone.
Tammy,
Yes,
there's only one landlord tenant left. It's case 215229. You should
Okay.
have that.
I should. I'll double check, and then I'll send Ms. Shava a message.
Thank you.
Thank you.
All right, good morning. This is file 211601SD, People versus Gerald Harris. And let's see, Mr. Brignoli is here on behalf of Mr. Harris. And good morning.
Morning.
And is there anyone here from the prosecutor's office this morning? I don't think so. So anyhow, it's my understanding there was a pretrial offer to plead to an impaired operate a vessel. Is that what your client wishes to do, Mr. Brignoli?
Excuse me, that's an accurate statement, Your Honor.
Okay. So, Mr. Harris, is that also your understanding?
Yes, Your Honor.
All right. Do you understand that by pleading guilty, you will have a conviction for operating a vessel while visibly impaired, and that carries a maximum penalty of up to 93 days in jail. Do you understand that?
Yes, Your Honor.
Has anything been promised to you to get you to plead guilty, or have you been threatened, forced, or coerced in any way to get you to plead guilty?
No, Your Honor.
I should point out that the pretrial memorandum also indicates there will be a dismissal of the civil infraction, but I'm not clear what that is. Mr. Brignoli, can you help me out?
I'm looking for the ticket, Your Honor, as we speak right now, and for me, it's I'm unable to read it in the pretrial sheet that I got sent via fax. Didn't have that on there. I knew there was going to be, we believe there was going to be the dismissal. So if the prosecutor is able to read that, I think he just logged in. He might be able to say it. I can't read it on my ticket, but it's,
All right. Yeah, I can't read it either. So is that Mr. Chamberlain? Yeah,
Yes, sir.
Mr. Chamberlain, we had a question about the pretrial sheet. It indicates the civil infraction is going to be dismissed, but I don't know what that is.
I'm looking for it right now, Your Honor.
it's, Your Honor, I think I have it right here. No BSC, so I'm not sure. So it's PWC dash no BSC. Remote, maybe voter safety certificate of some sort.
That's what yeah.
Okay. So I guess other than that, Mr. Harris, is there anything that's been promised to you, or have you been threatened, forced, or coerced in any way?
No, Your Honor.
All right. Has Mr. Brugnoli gone over your rights with you and answered all your questions to your satisfaction?
Yes, Your Honor.
I do need to go over your trial rights with you, make sure you understand those before I'm able to accept a plea. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have the right to a jury trial to make that determination. Do you understand all that?
Yes, Your Honor.
You also have the right to have the witnesses against you appear at trial to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand that?
Yes, Your Honor.
In addition, you have the right to testify at a trial, or if you choose to remain silent, and that silence cannot be used against you in any way.
I understand.
And finally, by pleading guilty, you give up the right to appeal that you'd have if you went to trial. And any appeal would be by leave, but not by right, meaning it would be up to the appeals court whether to even hear any appeal of your conviction or sentence. Do you understand that?
Yes, Your Honor.
And do you wish to waive all those rights in order to plead guilty?
Yes.
All right, then. Is it true that on let's see, June 12th, you were operating a motorboat on a lake in Glen Arbor Township, Leelanau County, and you were apparently confronted by a police officer. Is that right?
Yes, Your Honor.
And had you been drinking prior to operating your boat that day?
Yes.
And would you agree you had enough that your ability to operate the vessel was visibly impaired, meaning another boater might have noticed that you had consumed alcohol and it was affecting your ability to operate that vessel?
Yes.
All right. I see there was also a breath test given. It was an 09. Is that consistent with your drinking, at least on that one occasion that you had a substantial amount of alcohol in a short amount of time?
Yes.
Okay. Then to the charge of operating while visibly impaired, marine safety violation, how do you plead?
Guilty.
All right, I'll accept your plea, find it's voluntary, accurate, and understanding. So let's see, Mr. Brugnoli, is there any prior criminal history?
None at all, Your Honor. The client also did an assessment right away, which we've submitted to the court. So we're hoping that because of his lack of criminal history, we can proceed to sentencing.
Okay, we'll go ahead and do that then. Mr. Chamberlain, you're not aware of any prior criminal history?
No, Your Honor. Thank you.
All right, give me just a minute to review the assessment. Okay, so Mr. Brignoli, what would you like to say on behalf of your client?
Thank you, Judge. Your Honor, as you're just aware, this is my client's first criminal conviction. Again, this is going back to jets on a jet ski. Unfortunately, made bad decisions. It's summertime. He had an opportunity to make a delivery up to your area, and the owner of the home allowed them to stay up there and have access to their watercrafts and use it. And they stayed overnight. And unfortunately, he just had a few too many drinks. Blood alcohol was pretty low, and he was stopped in the wake zone at just too high of a speed. Your Honor, he's taken complete responsibility for this. He's very aware of the consequences if he was in a vehicle. He's a CDL driver for Chelsea Lumber in Chelsea. He lives in Chelsea. He's been there for 3 years. He's grateful for this opportunity because he knows that this could have affected his CDL. He's married. He's divorced. He's got 3 kids, and he is able to pay all fines and costs today to hopefully avoid probation. I know it's been a short time that he's been having this case pending, but I know that he's been doing everything that's been asked by the court. So with that, Your Honor, the fact that he can pay all fines and costs today, it's his first offense. I would ask you to sentence him to fines and costs only. If there is probation, I'd ask that it be non-reporting because he does live in Chelsea, Your Honor. Thank you.
Okay. Mr. Harris, is there anything you'd like to say before I sentence you?
Yes, I would like to. I like to say that I've learned a valuable lesson on this. I made a poor decision on that day to operate a jet ski while drinking. I made a poor decision. I'll make better decisions in the future. If I drink, I will not operate any type of vessel or vehicle if I've been drinking, Your Honor.
Okay, thank you. Mr. Chamberlain, anything for the people?
Your Honor, this is my case, but no comment.
Oh, I'm sorry. Thank you, Mr. Donaldson. Go ahead.
He said no comment, Your Honor.
Oh, no comment. I'm sorry, I missed that. Okay, so this is sentencing on the defendant's conviction of violation of marine safety, operating impaired, and the facts as I know them are that the defendant was on a jet ski and apparently going too fast. That's why he was stopped by the officer and had been consuming too much alcohol. It was a PBT of a 118 and a 09 on the breathalyzer at the jail. He would have been, I don't know, was he arrested? Did he spend an overnight or just booked in, or do you know, Mr. Brignoli? Or Mr. Harris?
He didn't stay that long, Your Honor, because
I stayed one night in jail that night, Your Honor.
Okay, thank you.
Detox.
All right, so the assessment indicates that the defendant does meet DSM-4 criteria for alcohol abuse. He appears to be a social drinker, but he's had past involvement with AA because of, well, no criminal involvement, but apparently there were some problems back in 2018 surrounding his divorce, and he engaged in AA for a couple of years. And so there seems to be a little bit of a pattern of alcohol abuse that's affected the defendant's relationships, and now he's gotten involved with the criminal law. So I think there is a rehabilitative interest in placing the defendant on a probation for 6 months and following the recommendations of the case manager, which is for the defendant to continue his re-engagement in AA. I'm going to order 2 meetings per week during the term of the probation, as well as I will order, let's see, 8 times a month testing for alcohol. There's no indication of a drug problem, but I'm going to order that the defendant not consume or possess alcohol for the term of the probation. And the way I figure out if someone has more of a problem than what it lets on is that if they are unable to follow probation because they're willing to risk jail than being sober. So anyway, hopefully that's not the case. The defendant is appropriately more remorseful in this case. Otherwise, seems to be a good citizen, and but I think some re-engagement with AA and just assuring that there's not more of a problem here than I'm seeing on the surface by requiring abstinence is important. So the fines and costs are going to be a $100 fine. It's $400 cost, $75 crime victims fund, $50 judicial system fee, and there's a $125 arresting agency fee. There, the probation again is 6 months. There will be a review at 3 months if the defendant requests that. And so if he's met all the conditions of the probation after 3 months, I will consider whether to release him at that time. So no positive tests, no missed tests, and following all of the other conditions of the probation. Even though this was a boating case, I think it would make sense for the defendant to take the alcohol highway safety program and victim impact panel. Obviously, on a jet ski, he was probably more likely to injure himself than other people, but this could have resulted in an injury to some other person. And also because I have a concern that I think is justified if there's an alcohol abuse problem that possibly it carries over into his driving. There's no evidence of that, but the fact you get on the jet ski drunk and that's enough for me to be concerned. And I think because we don't have a specific boater program, I think it would be good for him to complete those. Again, the conditions of probation will be not to consume or possess any alcohol, no mind or mood altering substances, no illegal drugs, obviously, and no non-prescribed medications. If you do have a prescription, make sure your probation officer is aware of that by providing them a prescription within 48 hours of obtaining that. There'll be discretionary testing only for drugs, so that your probation officer would have to suspect something in order to do a test. And then with the alcohol testing, I do want to make it eight times per month, and your probation officer will have the discretion to reduce that at some point if you are doing well. And let's see, the other conditions are that you be respectful of all court employees and care providers, attend AA twice per week during the term of probation.
You didn't mention marijuana. You want to.
Oh, no mind or mood altering substances, which includes marijuana. Although if there's a prescription, I guess there's nothing I can do to prevent him from using that. So let's see, but there's no indication he uses anyway. But anyhow, the other conditions would be that the defendant's not to operate a vessel with any amount of the substances I described earlier, or a motor vehicle for that matter, And I think that's it.
Judge, is there a number for probation I can get that he can call today?
Yeah, this is the probation number. It's 231-922-6899.
All right, thank you.
And there is also credit for the two days in jail. And that's it. So, all right, we're all set for today then. Good luck to you, Mr. Harris. Hopefully you at least get something out of this as far as not letting alcohol control your life here, or at least not letting it get you into bad situations like this. So anyhow, thank you, and we're all set for today. Thank you, Mr. Nolan.
Thank you, Judge.
Thank you. Thank you, Your Honor.
Yep. Okay, let's go on to Gabriel Keys, and that is People versus Gabriel Keys, file 211549, SM2. And let's see, Mr. Donaldson is here on for the People, and Mr. Rasby is here for Mr. Keys. This is the date set for sentencing on defendant's conviction of child abuse, 4th degree attempt. And Mr. Rasby, have you had an opportunity to go over the pre-sentence report with your client, and is it accurate and complete?
Yes, it is, Your Honor.
And so what would you like to say then on behalf of Mr. Keys?
Your Honor, before I begin my allocution, I would just point out that the report does indicate that he missed his original PSI. Mr. Keys had a spam blocker on his phone, and so unknown numbers or blocked numbers go directly to voicemail. He missed that. That's on him. He knows, well, that's been fixed. I guess that's the main thing that for the court to know. It was rescheduled. He certainly appreciates that, because I do think a lot of beneficial information is in this report. The report also indicates that he does have prior offenses 6 years ago. Mr. Keys explains to me that he did successfully complete both of those terms of probation back in 2015. Moving forward as to what happened here, this is a very difficult case. The facts and circumstances are difficult, but I would commend Mr. Keys for his behavior after his arrest. When I was assigned this case, Mr. Keys had already been involved working with DHHS as well as CPS, trying to remedy the situation here. He absolutely did not rise to the occasion when the incident occurred. He understands that, but he has put in a lot of good work. He did the family team meeting prior to me being assigned. He had already had a safety plan in place. He did the parenting journey. He's 6 weeks of 12 into that. He plans on continuing with the wraparound services as well as the Wellspring Family Support Program. So this isn't just lip service. This is someone who's actually taking action. And that's clearly the most important thing at this point. So that nothing like this ever happens again, and that the family can move forward in a healthy manner. With that action, the prosecutor's office did seem to recognize that. After Catholic Human Services reached out with his progress, the prosecutor's office was able to extend this plea offer that Mr. Keys has accepted. He is very appreciative of that. As more time progressed and he continued to work with the counselors and the services provided, eventually he was given a little more latitude, and the no contact was lifted. He's extremely appreciative of that. These types of things I think are important because it does show that he's putting in the work and progress is being made. I think that's echoed by the PSI. His interview with probation indicated he was truthful, remorseful, embarrassed, and accepts responsibility for his actions. that's where I'm at with Mr. Keys as well. All of those things are true statements in my dealings with him. He is very embarrassed and remorseful for how he handled this. When he was in the heat of it, he didn't rise to the occasion, and he wants to do better. The recommendations, they are fair, they are justified. He's going to continue to put in the work. There is a recommendation for some jail. I would ask that the court consider perhaps community service, a smaller or short jail sentence, or holding a jail in abeyance. Obviously, there's 180 days here that are possible for Mr. Keys to serve. The most difficult part of this process, I think Mr. Keys has probably already gotten through. And that was when this happened, he was unable to have contact with the children. He was unable to apologize. He was unable to comfort, to do anything that a father would want to do. And that no contact was in place from March 25th to June 8th. So that was very, very weighing and left an impression on Mr. Keys. He wants to be a good dad. And I do think that the structure and resources are in place, and he just has to continue to follow through. So with that, I would ask that the court consider my comments, and I know that Mr. Keys would also like to address the court.
Okay, thank you. Mr. Keys, I would like to hear from you.
Yes. Can you hear me well? Good?
Yes, I hear you just fine.
All right. I am very remorseful and I do regret my decisions. I've expressed that in many different ways with the groups and the parenting people and establish a relationship with them. And I do know that reaching out for help always, is not always a bad thing. And I handled the situation poorly, and I cannot make decisions like that, ever again. And I hope that, my choices will teach my kids to be better than me and make better choices as well. And I will pay the price. And I do want to get better and raise my kids properly and do whatever I have to not only better myself, but better my children as well. But that was the wrong way to go about it. And I am grateful for these services that I am currently enrolled in and look forward to continuing them. And I am sorry.
All right, thank you. Mr. Donaldson, anything for the people?
Your Honor, I think Mr. Razovy has done a yeoman's job in representing Mr. Keys. I know the court has had an opportunity to review the incident report and the pre-sentence report. The behavior of Mr. Keys in this instance is nothing short of bizarre. In the age of his children at the time this occurred is such that it had to be a very traumatic experience for them, and I don't hear a particularly cogent apology as it would relate to how it's affected them, or acknowledgement of that may be because Mr. Keys is having difficulty articulating that, but it's a serious offense, and I hope he makes progress and continues to make progress.
All right, well, thank you, Mr. Donaldson. So this is sentencing on defendant's conviction of attempted child abuse, 4th degree, and the facts are, as Mr. Donaldson indicated, rather bizarre, and I guess I'm not going to go into detail. We all know what happened, but hopefully the classes that you're taking through Catholic Charities, the parenting journey, and that have taught you that what a 7-year-old does, how they act out, has nothing to do with adult behavior. And I think this is a case of overreaction, but also, I can understand some of the behavior, but punching your son in the ribs, slapping his glasses off, the length of time that this went on over a 2-hour span, it says, I agree with Mr. Donaldson. This had to be very traumatic for the children, the 7-year-old and the 11-year-old. I do think, even though I didn't hear an express apology to the kids, I do think Mr. Keys appears remorseful for his behaviors. He seems to be learning from the classes he's taking and understanding that what he did was not appropriate. The problem is, Mr. Keys, that kids, they watch everything their parents do. They worship you. And when they see how you behave, they tend to repeat those behaviors. And that's why we get this cycle of domestic violence. Little boys grow up to abuse women, and little girls seem to take it. And I know you don't want that for either of your kids. You want them to have healthy, normal relationships. And so it's important to address those issues. I thought the recommendations here were actually very thoughtful because it's all focused, the probation is all focused on parenting skills. So anyhow, on the bright side, well, I should mention also the defendant does have a history that includes domestic violence in 2015 and impaired driving the same year. And so that's concerning only because this is, again, an assaultive case, and there is a prior domestic violence. On the bright side, though, the defendant is a high school graduate. He is gainfully employed doing home repair and remodel, which is a good skill to have and a valuable skill to have as well. He has engaged in the counseling that's been required through DHHS and Child Protective Services, at least as far as I know to this point. And the probation officer found that the defendant did appear to be remorseful, embarrassed, and accepting of responsibility for what happened. For those reasons, I am going to follow the recommendations here. The probation is going to be for 365 days. Let's see. I'm required to inform you that I will consider a petition for early discharge from probation on completion of 6 months of the original term of probation. I think that's unlikely, though, in this case, because of the number of services that are recommended and because of the seriousness of the offense, the fact that you have a prior record of domestic violence. So don't count on that. The fine is going to be $100. There's $400 in costs, $75 Crime Victims Fund, $50 judicial system fee, and there's a $250 court-appointed attorney fee as well. The terms of the probation are going to be that you not consume or be in possession of any alcohol, you're not to use any mind or mood altering substances, including marijuana, no non-prescribed medications or illegal substances. You're not to behave in a violent, threatening, intimidating manner toward anyone and be respectful toward all court employees and care providers. You're to attend, cooperate in, and complete the parenting journey and follow all of the recommendations, comply with all your DHHS and CPS orders and follow their recommendations. There will be discretionary drug and alcohol testing at the request of either court employees or law enforcement.
Okay.
Let's see, as far as the jail time goes, it's recommended that there be some jail time. And I do agree that based on this being your third involvement with the law, 2 assaultive offenses, the fact that this involved a assault on a 7-year-old child and the fact that the incident occurred over a 2-hour span, there does need to be some jail time. Now, this is a Hobson's choice here because the defendant is important to the continued financial support of those same children. The no contact has been lifted to some extent, and
Your Honor.
so yeah, go ahead, Mr. Razzaby.
Just before just to clarify, the offense was against the 11-year-old son, and Mr. Keys was trying to protect the 7-year-old daughter. Just for
I'm sorry.
That's okay.
I'm sorry, I did mix that up.
The other thing
It's the 11-year-old.
Perhaps the court should be aware is that his next class is Wednesday, this upcoming Wednesday.
Okay, thank you.
Is that
All
class
right, so-
virtual? Is that
What
class
was the
virtual,
question?
Mr. Razzaby?
Mr. Keys, are you attending those in person or over the internet?
In person. I had one via Zoom that Melissa had on her phone, FaceTime, only because I had the children with me and I didn't take them to the class. And she said that I could miss 3, but I didn't want to miss any. So they were here at the house and I was on the phone. So,
Okay, but those are in person with the children.
correct.
Thank you.
All right, so this is what I'm going to do. I'm going to sentence the defendant to, what I had here was 10 days in jail, but what I'm going to do is it's going to be 5 days in jail, 5 days of community service work. The defendant is to begin his sentence today. You're to turn yourself into the Leelanau County Jail no later than 6 p.m. tonight. Again, this is the second assaultive offense. It involved a child, and actually it probably deserves more, but I don't want to lose sight of the fact that you're making progress in these parenting classes, and that ultimately I could put you in jail for 6 months, but ultimately what matters to those kids is that you be a better parent. So I'm going to make it the 5 days in jail. The 5 days of community service work is in lieu of additional jail time. And I will accept if you can, I don't know, build a handicap ramp or something like that for someone at no cost but materials. I would accept that kind of work as community service work. Hopefully you can do something meaningful in the community. So that is it for the sentence. You do need to contact the probation office between 1 and 4 p.m. today. They're going to go over the conditions of probation with you in more detail, answer any questions that you have. And that phone number is on the report.
Did you say Sutton's
Anything
Bay?
else for you? What's that?
Does he realize it's Sutton's Bay Jail? Because he actually has a
I
Traverse City
mentioned that,
address.
yep.
Okay.
Okay, so Mr. Rasby, anything else for you?
No, Your Honor, thank you.
Mr. Donaldson, anything else for the people?
Nothing, thank you, Your Honor.
Okay, well, good luck to you, Mr. Keys. And I hope not to see you back here except to discharge you from probation successfully, okay?
Okay, thank you, sir.
All right, thank you.
Thank you, Your Honor.
All right, let's go to People versus Timothy Mikovits. And that is file 211527 SD. And let's see, Mr. Mikovits, do you have an attorney for this? It says Mr. Pedersen.
Yes, Your Honor.
Ms.
I'm here for
Ascione.
Yes.
Okay, so good morning, Ms. Ascione, and
Morning.
Mr. Donaldson is here for the people. And are you able to hear me okay, Mr. Mikovits?
Yes, I can, sir.
All right. So this is the date for sentencing on defendant's conviction of operating while intoxicated. And I'm going to mute the jail because I'm getting some feedback there. There we go. All right. So, Ms. Ascione, have you had an opportunity to review the pre-sentence report, and is it accurate and complete?
I have, Your Honor. And yes, it is. And
Okay,
I've also discussed it with Mr. Mikovits.
All right. Mr. Donaldson, were you satisfied with the report?
Yes, Your Honor.
All right, then, Ms. Ascione, what would you like to say on behalf of Mr. Mikovits?
Thank you, Your Honor. Mr. Mikovits is a 75-year-old retired widower. He lost his wife about a year and a half ago, and at that time is when he really started drinking. He abandoned all of his hobbies and really just had a hard time coping with the loss of his wife that he had been with for 60 years, been married to for 60 years, but known since she was 14 years old. Her death came suddenly due to cancer, and it was just a very traumatic experience for him and something he had a really hard time getting over with, and unfortunately resulted in him drinking. He understands the severity of his actions. He is very remorseful. I have, had several conversations with him during the course of this case, and I've just seen exponential growth in him. And I just can tell he is truly remorseful and sorry he's in this position. Sorry for the court. Sorry for himself. Sorry for his family. He did have an alcohol assessment through Munson during February of this year, which I believe Your Honor has a copy of. It reports that he does have some, alcohol abuse disorder, but it's also reports that they believe it's a result of the loss of his wife and the grief and depression that he was going through at that time. He has a very supportive family. He has 3 adult children, 8 grandchildren. His daughter, Bethany, has been exceptionally involved during this whole time. I've also had multiple conversations and emails with her. She is trying to help her father and successfully has helped her father in his recovery. He has attended AA meetings, peer counseling through Munson, grief counseling through hospice. He's seen an individual counselor, and he's also attended meetings at Michael's place. Since this case has started, he has moved from his home. He's now living in an independent living facility, Glen Eagle. He has really found a community of support there. He's made a lot of friends. He's noticeably happier. He's gotten a lot of support through that friendship and through that community he has at Glen Eagle. It's like I said, an independent living facility. They assist with 3 meals a day and assistance as needed, but mostly what he's grown from that is the friendships and the support through the grief and just overall mental health there. He has since sold his vehicle. I think that's important since he, you know, part of his charges were due to driving, and he uses his family Uber or Beta to get around since then. Overall, he's just in a position to commit to his sobriety and a healthy lifestyle. I do want the court to be aware that he has several physical setbacks. He has horrible joint issues and just due to, you know, we would ask that jail time would not be appropriate in this matter. He has several horrible joint issues, arthritis. He's unable to stand for very long. He uses an electric cart to get around. He's unable to walk more than 6 to 10 feet at a time, completely unable to do stairs. Even the one night he did spend in jail upon his arrest, he was very stiff and unable to move for days after that. Also, he has been waiting for a knee surgery that he's needed for years. He's been on the wait list and he's had to be in good physical health in order to get this knee surgery. He had a fall a while back, which postponed it, and then COVID postponed it. He's been waiting for years to get it, as I said, and that knee surgery is actually scheduled 4 days from now, on the 6th. So we've, you know, also had a chance to look at the pre-sentence investigation. The probation is not recommending jail time or probation. So we would ask that the court follow those guidelines in making their decision. And I know that Mr. Mikovits would also like to speak on his own behalf.
Ms. Ashion, I see that there are numerous misses with the PBTs.
Yes.
And I mean, what's the explanation for that?
Yes, so he's actually, the first machine that he was given, he did not have the lung capacity to blow into. He didn't know that, and the probation department didn't know that until after he had already gone home with it. He then received one that he could take at home. Basically, it's been a machine malfunction every single time. The second machine, it was not, I believe it was not, he was taking, there's been several incidents. First, he couldn't blow appropriately. Then the machine, he didn't understand the time frame he had to blow within. So he was blowing before 6 a.m. And then it was every time coming back as negative. We have talked to the probation department, me and Mr. Mikovits, talked to the probation department through all of these misses. We've talked to Smart Start, and since we've gotten the machines calculated appropriately, he has not had any misses, but I know there is a significant amount in the very beginning. But he has assured me, and he has assured the court at his bond hearing, that he has not drank.
All right, thank you. Mr. Mikovits, is there anything you'd like to say?
No, I think Jordan covered it all. I am remorseful. The sudden cancer of my wife was a total shock to myself, my 4 children, and my grandchildren, 8 grandchildren, and it was very tough. And I've learned that Michael's place in counseling, it's been the direct path I should have been in, but since I've been in the retirement home, I've met some absolutely wonderful people. And my recovery and my attitude and my personality is flipped right over. I feel very positive now in my life, and as looking back on it, and I just look forward to the future.
All right, thank you, Mr. Donaldson. Anything for the people?
Nothing, Your Honor.
Is Ms. Castis on the line?
Yes, sir.
Yeah, I'm just wondering, is that accurate that it looks like the last violation in this case was the, let's see, the 21st of May. Have there been tests since then? And, have they all been performed and negative?
Yes, Your Honor. The information we have from Smart Start is that since that time, the tests have come back clean and compliant.
Okay, and I seem to recall this issue coming up as a bond violation. Was there some action taken at that point? Because I'm not finding the action in court to address that.
There was a bond violation hearing, but there was no action taken by Your Honor.
All right. Okay, so this is sentencing on the defendant's conviction of operating while intoxicated. The facts are that the defendant was at Apache Trout Grill in the afternoon, had consumed alcohol there, and apparently drove over to the party store across the street and ended up falling over. He said his jacket got caught on a rack, but his preliminary breath test was a 0.23. And the report doesn't indicate what the data master reading was or blood test. Or excuse me, I'm sorry. The lab result is reported as a 0.23 as well. So so the defendant had a high blood alcohol concentration. That's what he was originally charged with. And I would note that's nearly 3 times the legal limit. The defendant comes to the court with a prior drunk driving offense where his probation was revoked. And that usually happens because there's non-compliance with the testing requirements. There is also a substance use assessment which indicates that the defendant has a severe alcohol dependence disorder. The defendant blames what happened on grief about the loss of his wife, and I am sorry for all of his grief there. There's no doubt that would be concerning to anyone, but the fact is the defendant turns to alcohol apparently when he's grieving. And the problem here is that with 3 times nearly the legal limit, you subjected the rest of the public to possible disaster and more grief. And this could have turned out very badly. And I'm sure you're relieved that nothing bad happened, but it's the second time around. And I've got someone with a severe alcohol use disorder. Now, the report also indicates that Mr. Mikovits is currently living at Glen Eagle. It's independent living, so this is not an assisted living environment or something like that. And says he's doing better. He's going to grief counseling at Michael's place and doing some, says a few SA counseling appointments. I'm not quite sure what SA, I'm assuming that's substance abuse counseling. But stopped doing that because he was overwhelmed with the Zoom. The defendant also indicates that he sold his car and no longer drives. His daughter also indicated that she didn't believe court-ordered treatment is necessary. But I'm going to tell you what, you're in independent living. That means you can go out tomorrow and buy a car. And if you go out and kill someone, people are going to wonder, what in the hell was Cooney thinking about? He's got someone with a severe alcohol use disorder, a prior drunk driving conviction. And the recommendation here is for no probation. Let's not overwhelm the defendant with Zoom meetings where he might address his substance abuse. Here you violated your testing. And I think I basically read the Riot Act back at that last hearing and said, you know, you need to start complying. I don't believe for a minute that you were having problems with your machine. You know, I've got two parents and I got two in-laws that are well into their 80s. They've got all their faculties about them. And if they did something like this, I'd expect them to go to jail on a second offense drunk driving. And if you think because you're 75, I wouldn't do that, I would. Because I don't want you to go out and kill some little kid because you're grieving. All right, so what's being recommended here is so inconsistent with what should happen for a second offense drunk driving with someone with a severe substance use dependence that I can't go along with this recommendation. This was a high blood alcohol concentration offense. So the probation is going to be for 18 months. The defendant can ask for a review hearing at the 9-month mark to be released from supervision if he's complied with all the conditions of probation. The fine is going to be $100. There's cost of $247. Crime Victims Fund $75. Judicial system fee is $50. There's an arresting agency fee of $125. The conditions of probation are going to be as follows. The defendant is going to continue the testing as required under his bond. How often are you testing, sir?
Twice a day.
All right, so we'll continue that. Your probation officer will have the discretion to reduce that testing at some point if you continue to do well. But frankly, your start date with all this is, I guess, May 22nd. Or no, there was a bond violation on 6/4. So it's going to be as of 6/5, I guess.
For what, Judge? I'm confused.
Twice a day preliminary breath test.
Oh.
I'm just saying
I
any testing prior to that really didn't count.
Okay.
You're also not to consume or possess any mind or mood altering substance, no non-prescribed or illegal drugs. If you have prescription, you need to provide a copy of that to your probation officer, so they're aware of what you might have in your system. There'll be discretionary testing for drugs and alcohol. You're not to go to any bars or casinos.
I was giving that to you to read off of, if you'd like. Sorry.
You're to be respectful of court employees and care providers, although I'm sure that won't be any problem. You're very respectful, and you've been a real gentleman this morning anyhow. You are to attend and complete the Alcohol Highway Safety Program and Victim Impact Panel. Or excuse me, no, we're not going to do that. We're going to require the Basic Awareness Program, which is the general counseling that would be required for a substance use disorder. So basic awareness group, follow all recommendations of your counselor, and attend 2 12-step meetings per week. Jail is credit for the time served, the overnight that you spent, and you're not to operate a motor vehicle without a valid license, registration, and insurance, and you're not to operate a motor vehicle with any presence of alcohol or the other substances that I described earlier. Let's see. I would consider individual counseling as opposed to the basic awareness group if that is something that you discuss with your probation officer and your probation officer believes that that is an acceptable person. It should be someone who is certified in substance abuse counseling. You're also to continue the grief counseling through Michael's Place and follow all recommendations of your counselor. Okay, so that's it for today. Is there anything else for you, Ms. Ascione?
No, that would be all, Your Honor.
All right, Mr. Donaldson, anything for the people?
Nothing, Your Honor. Thank you.
All right, and Mr. Mikovits, I know I may sound kind of harsh here, but I'll tell you, the worst thing you could do is go out and injure somebody, because I know that's, you know, you've lived a good life, and you don't want to go out under those circumstances. You do not want to cause that kind of grief to another family, and you need to take the alcohol abuse seriously. Your counselor wouldn't have reported that except he could see that, and you need to do something about it. So again, I'm sorry to hear about your wife, but you're not making things better by continuing with the alcohol. So, all right, we're all set for today. Thank you.
I do have just one thing, Your Honor.
Yeah.
During the time of his surgery, I'm not sure the timing, and if you, like, for purposes of blowing into the PBT, should he just make his probation officer aware if he's unable due to being under anesthetics or something?
All right, what he needs to do is talk to his probation officer about what date that's going to be. He would be relieved from testing requirements during that time period, but he just needs to keep the probation officer informed. And we would certainly expect that there would be some sort of anesthesia drugs administered. So, you know, that is not going to be a problem.
Okay.
Oh, and I should also mention that the defendant does need to call the probation office between 1 and 4 p.m. today. The phone number is 922-6899.
Thank you.
And they'll answer any other questions that he might have about the probation, okay?
Okay, thank you very much.
All right, thank you. You're all set, Mr. Mikovits.
Could I have that back?
I did not check all the boxes.
I know, so I filled this one out. I'm gonna have you sign that, then I'm gonna compare. Thank you. That's okay. And then I want to make sure you saw this for the Peasy case, because it was in an unindexed folder. It's next in line 2 cases, but I wanted to get that to you.
Okay, thanks. All right, this is People versus Christopher Wozniak. And Is Mr. Wozniak here?
He's on the phone.
Yeah, he
Mr.
just went
Wozniak?
to the bathroom.
Ah, okay. Well, we'll wait
Here
for
he is.
him then. He's back?
Yep.
Okay.
Mhm.
Mr. Wozniak, can you hear me okay?
Oh, sorry. Here.
Over there
Yeah. Here we go.
for me?
Yep.
Hello?
Yeah, Mr. Wozniak, can you hear me okay?
Yes, Your Honor.
All right, so this is file 201401SM, People versus Christopher Wozniak, and the defendant is here, I believe, in pro per for this probation violation hearing. Or is there an attorney, Mr. Burdette? You're not representing Mr. Wozniak, are you?
No, I'm not, Your Honor. I represent Mr. Gilbert.
That's what I figured. Okay. And let's see, Mr. Donaldson or Mr. Chamberlain, who's here for this?
I'm here for
I-
this one. Thank you.
Okay, so Mr. Chamberlain's going to take this one. And this is a probation violation hearing. So the allegation is consumption of alcohol and an arrest on May 21st. And let's see, Mr. Wozniak, you do not have an attorney, is that correct?
Yeah, that is correct. I am representing myself, Your Honor.
Okay, and I just want to remind you, you do have a right to a hearing and to an attorney to assist you, and the court would appoint one for you at public expense if you were unable to afford that. Do you understand all that?
Yes, Your Honor. Yeah, I couldn't afford it after the fact. And anyways, I didn't know that that the court gave you an opportunity to use the defense when you have a probation violation. Through my experience, through any other county. So it's kind of new to me.
Okay, well, are you saying you'd like to have an attorney for this?
Oh, no, I got it, Your Honor.
All right. Well, what I'm asking you is, do you want to waive your right to an attorney, including one appointed at public expense, and to a hearing and plead guilty?
Yeah, yes, Your Honor. I just represent myself.
Okay, but do you want to have a hearing on this, or are you going to admit to the violation?
Oh, yeah, I'd like to have a slate hearing on it.
Okay, well, I don't know about slight. We kind of do the full thing here, but so let's go ahead with the hearing then. You do want to waive your right to counsel, though, correct?
All right, sure, yes.
Okay. All right, so Ms. Morton is here for the probation office. Are you prepared to go ahead?
Yes, I'm ready.
Yes, Your Honor.
Okay. All right, so Ms. Morton, could you please raise your right hand? Do you swear or affirm that the testimony you're about to give will be the truth?
I do.
All right. So is it true that Mr. Wozniak was placed on probation for attempted resist and obstruct a police officer on April 9th?
Yes, Your Honor.
And now the violation says that, well, as a condition of his probation, was he not to consume or possess alcohol?
Yes, Your Honor.
And another condition was he was not to violate the criminal law. Is that correct?
Yes, Your Honor.
All right, and since he was placed on probation, are you aware of a criminal complaint against Mr. Wozniak?
I received a police report for an incident that occurred on May 21st, where he was arrested for drunken disorderly in a public place.
All right, and did you speak to him yourself about that?
I did not. I only received him as a probationer on June 1st. So his old probation officer, Ms. Helmrich, was the one that spoke to him and prepared this violation regarding that charge.
So where it says he admitted to consuming alcohol, he made that statement to Ms. Helmrich then?
yes, he did not make that to me.
Okay. So Ms. Helmrich is the one that actually prepared this report.
For the first violation, and I'm not sure if Mr. Wozniak knows of the additional violations of the missed PBT on June 30th and July 1st.
That's not true, Your Honor. That's not true, Your Honor. I've actually provided documentation, sufficient documentation.
Okay. Mr. Wozniak, you're going to get a chance to ask Ms. Morton questions yourself, and I'll give the prosecutor an opportunity as well. But right now I'm asking the questions, so I'd ask you to hold on to your questions until it's your turn, okay?
I apologize, Your Honor.
No problem. All right, so Ms. Morton, as far as the added violations, it indicates in the report that the defendant, as you've already testified, that he missed tests on June 30th and July 1st. Says he failed to appear for PBTs. What records do you have to show that?
I have 2 testing from New Direction Testing where they sent me a missed PBT on June 30th and July 1st for Ash for his order number.
Were there any notes on those violation reports to indicate that they smelled alcohol or whatever? Sometimes they put notes on them.
He didn't show up, so there was no notes.
Oh, I'm sorry. And no contact with him calling in or being late or something. He just didn't show up at all.
I can't say for sure for my voicemail. I'm so far behind in voicemail, but I have no email from him for him providing proof that he took them.
Okay, but the as far as the violation sheets themselves, they don't provide any additional notes explaining what happened. Okay.
No, you're
all right then. Mr. Chamberlain, do you have any additional questions for Ms. Morton?
I don't at this time.
All right, so Mr. Wozniak, now's your chance to ask Ms. Morton questions. Do you, and this is the thing, you can ask her questions, but if you just want to tell me what your side of the story is, you can testify also. I'll swear you in and you can testify to it. So do you want to ask any questions?
Yes, I do have some questions for Ms. Morton. Ms. Morton,
okay, go ahead.
Yeah, Ms. Morton, there's no doubt that during the transition between Ms. Christie and yourself, that there was miscommunication on who's representing who and who's filing a report, and that was presented very well by yourself. And I got an email from you from after the 30th when I did provide documentation. I forgot to grab the receipt, and you said, "Did you grab a receipt?" And I said, "No, I'm sorry, I forgot the receipt." And then I told you, I gave you a follow-up email on the first when I also had a PBT. And this was down in East Grand Rapids, which I told you in an email. I got confirmation on an email from you. And I don't believe you maybe read your newest email, which was from yesterday. And on the 24th of June, that was my call-in date to give a description on my probation status and everything on my part, which I did through the instructions of, I forget the lady who gave me the email address, but she gave me your number and your email. And I gave you a description and follow-up within 2 days of my fourth Wednesday, which is the time to provide all that information. And that would be it.
Okay, hang on then, Mr. Wozniak. Let's hear from Ms. Morton.
I apologize. I did send him an email on the 30th telling him to report, and I did send him a form. He advised he did take a PBT June 30th at East Grand Rapids. He provided me just a sheet. I asked for a receipt with signature because I can't verify that signature. I asked him for a receipt from June 30th, verifying he took it. He did email back, say he lost the receipt for June 30th. So I really can't verify that PBT because it's a signature
Okay.
sheet. Anyone could sign it. I will say he did send an email yesterday, and I would ask to dismiss the PBT for July 1st. There is a receipt from New Direction. Or there is a new receipt from, looks like East Grand Rapids. So I don't
Your Honor.
necessarily verify the 30th, but the 1st I would ask to dismiss.
All right. Do you have any additional questions for Ms. Morton, Mr. Wozniak?
Well, yeah, Ms. Morton, I cannot go to a separate department from where I was going before and ask them, hey, can you do the receipt in my favor? You know, they go by a checklist, which is on the wall, and they went from 1 to 5 to 6, whatever, and then they did everything they're supposed to do. So I can't tell them, hey, do something different for my probation officer. I mean, my probation officer needs to tell them, hey, this is how I want done. And I can't really do that, you know.
Mr. Wozniak, can you please, let's follow the process here, okay? I have to have some order. What you're doing is you're not asking a question, you're just making some argument, okay? And actually, it's a pretty good argument, all right? I am going to give Ms. Morton a chance to respond if there is anything you want to say regarding that argument.
Well, the thing is, in Ms. Morton's response,
not you, Mr. Wozniak. I was asking Ms. Morton, so let's let Ms. Morton respond, okay? One person at a time, thank you. Okay, Ms. Morton, was there anything you wanted to say about that?
I would just like to say it's not my responsibility to provide proof that you took your PBT. It is the probationers, if they test out of town, to provide proof to me that they took a PBT. A signature sheet could be done by anyone. That's why I ask for receipts.
Okay, thank you. Now, Mr. Wozniak, this is the thing. The 7-1 PBT, that's being dismissed because Ms. Morton now has proof of that. But if you want to testify about whether you did in fact take a test in East Grand Rapids on June 30th, now would be the time to do that, or to address this other incident on 5/21. So do you want to do that?
Yes, let's do it.
I want to advise you that anything you say during this hearing about the 5/21 incident could be used against you by the prosecutor. Do you understand that?
The charges were dropped, so I don't completely understand that. I don't know how charges can be dropped and picked back up. I have an email stating that charges were dropped from that incident, so I don't know how I could be picked up for new charges. I'm being charged with a probation violation.
Hang on. I don't know whether they've been dropped or not, because all I know is it says in my probation violation report. Ms. Morton or Odom, do you know anything about that?
I do not.
Okay. All right. Well, I'm just advising you. Oh, Mr. Chamberlain, do you have more information about that?
Yeah, I rather than charging a new case, I just decided to treat this as a probation violation. If I could have just asked 2 questions to Ms. Morton based on what's been discussed, I'd appreciate it.
Okay, go ahead.
Ms. Morton, was Mr. Wozniak arrested for drunk and disorderly on 5/21?
Yes, that's correct.
And are you aware that he had a PBT at booking at the jail?
I contacted the jail the other day because I couldn't find the PBT in the police report, and the jail told me he refused a PBT at the jail.
I actually have a PBT at the jail of 0.153 at 1735 hours.
Okay.
I can provide that to the court and to you, and I'll get that right now. I have no other questions, Your Honor.
Okay. Do you wish to present that evidence, Mr. Chamberlain?
I do. This is from the booking sheet on 5/21. It has his PBT at 0.153. I'll take a screenshot and I will send it over to, should I just send it over to Tammy?
Yeah, that's fine.
I'll do that. Right
Tammy Odom, yeah. Okay, so do you have any additional questions, Mr. Chamberlain?
No, Your Honor, I think that's sufficient.
Okay. All right. So, Mr. Wasnak, it sounds like the prosecutor is here. He's saying he's not charging you. So, anyway, if you want to testify, that's your right. So, is that what you want to do?
Well, yeah. Can I just testify?
Okay.
Yeah.
So, please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth?
Absolutely.
Okay, so let's see. Mr. Chamberlain, why don't I let you ask the questions here?
I'm sorry, I was trying to make sure I could get this over to you. You asked if you wanted me to ask questions, Your Honor?
Oh, well, actually, let's let Mr. Wasnak explain his side of it first, and then I'll have you ask questions, okay? So, Mr. Wasnak, what do you want me to know about the June 30th violation?
I got a question. What am I being charged with? Is this still the probation violation?
Yeah, this is a probation violation. This is the thing. Mr. Chamberlain has stated that he's not going to charge you with the drunken disorderly. He's decided that I could deal with it as a probation violation, or he would prefer to see it just dealt with as a probation violation on this case, okay? So,
right.
Therefore, any statements that you make under those representations, I don't think could be used against you to reassert that charge, and I don't think that's Mr. Chamberlain's intention at this time. So I think you're free to talk about that incident. So, so go ahead. You're not being charged with anything else except this probation violation. So I'd like to know, did you test in East Grand Rapids on June 30th?
Absolutely, 100%. And I can provide documentation through a FOIA. And that's what I was told on the first, because I had gotten an email from my newest probation officer, and I told her that I failed to keep that receipt, and the only way, I didn't tell her then, but yeah, the only way I can receive it is through a Freedom of Information Act, which seems extreme.
Okay.
But that's what it is.
Now, were you arrested on May 21st for drunken disorderly?
Those were the charges.
And they've been dropped since, correct?
That is correct.
And is it true you were intoxicated?
There was documentation from the that said I failed a PBT. I don't believe so, to my understanding.
So you're denying that you used alcohol?
Well, they say I used alcohol, but I guess, yeah, I did drink.
Okay.
Can I explain that day? Can I explain that day?
Absolutely. Tell me whatever you want me to know.
On May 21st, I actually denied my surgery for a hip replacement, and the reason behind that was because my son was going to be born early, and which he was born 1 month premature on June 7th in Traverse City, and then I would have been 2 weeks into I would have been 2 weeks into a hip replacement recovery when my son was born. And I'm currently down in Grand Rapids, and because he's at the Helen DeVos Children's Hospital, and he's doing good. But
okay, Mr. Wasnak, okay, congratulations on your son and everything, but I don't know what this has to do about my question whether or not you consumed alcohol or not. Are you denying it, or did you use alcohol?
I may have.
Okay. Mr. Chamberlain, do you have any questions for Mr. Wasnak?
I think I have a sufficient basis, so I don't think I need any other questions.
Okay, so Mr. Wozniak, I'm going to give you one more opportunity to tell me anything you want me to know about this, but you need to keep it relevant. Okay, go ahead.
Well, I had drank on that day, and I know it was in violation, so I did violate, but I disagree with the terms of the violation, like the sentencing guidelines behind that, just because of the current situation I'm involved in.
With the hip replacement and your son being born, is that why?
Yeah, well, I'm currently down in Grand Rapids because my son's in hospital down here.
Okay. All right. Well, all right then. This is a probation violation hearing, and I do find that the defendant violated his probation by consuming alcohol. There's evidence of a 0.153 preliminary breath test. Defendant was arrested, and later the charges were dropped, and that's the prosecutor's discretion. But at least for the consumption of alcohol, I'm going to find that the defendant is guilty of that. I'm also going to find that the defendant did comply with his PBT testing on June 30th and July 1st. There's some evidence to back up what the defendant said about testing in Grand Rapids on the 30th. He sent an email to the probation office, and I'm going to take his word for that. On the July 1st incident, that's been dismissed. The defendant does have no prior probation violations, but there were a string of previous bond violations. The defendant has served 8 days in jail already on this offense as of May 27th. Mr. Chamberlain, is there anything you'd like to say regarding this violation and what you think I should do? And I'm going to give you a chance to say what you think should happen as well, Mr. Wozniak.
Your Honor, a 0.153 is extremely high, especially for a probation violation. I'm glad he wasn't driving. I believe his wife was driving the vehicle at the time, so that's good that he knew not to drink and drive. However, I am concerned about possible skirting around this issue. If you decide to continue probation and a CAM device is now available now that we have reduced restrictions on COVID, I think that would be appropriate, Your Honor.
Okay, Mr. Wozniak, anything else you want to say before I decide what the sentence is going to be?
Well, I was referring back to the 21st of May when the incident happened. I had called off my surgery, which I had planned for and everything. I called it off an hour before it happened when checked into the hospital. I had12 in 12 hours or whatever, and because, through whatever you got to do. So I had like an empty stomach, so I did drink because I was kind of under a lot of stress and everything. And a lot of it's kind of due to a financial obligation in one way or another. And the PBTs, one way or anything, they cost money. And I'm down in Grand Rapids. I paid $15 for each of the last two, and that's a lot of money when you don't have money to deal with, and you're kind of like on the brink, and helping your kid out. And I just went and signed a 1-year lease on a house in Grand Traverse County, and so I'm hoping to move in there within the next few weeks when my kid gets out of the NICU. So it's kind of a hectic time. So I don't know. I'd say just continue on probation as it is, and I know I'm 1 month behind on my payments. But my whole idea is to make a double payment by the next payment that's due. So that's all going to be on track.
Okay, thank you. Well, I might be more sympathetic if it weren't for the fact that when I look at the prior record in this attempted resist and obstruct a police officer case, you've got a prior felony resist and obstruct in 2020, trespass in 19, controlled substance charge in 18, suspended license 16. In 2015, it was operating with suspended license, failed to report accident. 2011, drunken disorderly. 2010, minor with a BAC driving a car. 2010, operate intoxicated, a disorderly person in 2008. And here you are, you're on bond, or excuse me, probation, and you're not supposed to consume alcohol. And I don't understand for the life of me if your son is in the hospital down there and there are issues there that you go out and drink alcohol at a time when your son needs you. So this is what I'm going to do. Okay, Mr. Wozniak, I gave you an opportunity to speak. Now it's my turn.
On June 7th.
All right, Mr. Wozniak.
Yes.
You're done. Okay, it's my turn to speak. Your probation will be continued, but I think the recommendation for 5 days in jail, additional days, is appropriate. So that's what it's going to be. You need to, you're in Grand Rapids right now, is that right?
That's correct.
And let's see, how long is do you know when your child is going to get out of the hospital?
It's unforeseeable, you know, it could be a few days, could be a week, could be weeks. I don't know.
But your wife is no doubt down there, right?
Yeah, me and her are staying together.
Okay, so you're going to have to turn yourself into the Leelanau County Jail. I'll give you until Saturday at 6 p.m. You're turning yourself in for the additional 5 days. And I think we're going to go along with Mr. Chamberlain's suggestion that you be put on a cam device, because we just can't trust you to not use alcohol. So you'll be released from the jail upon the application of that cam device. Okay?
How much does that cost, Your Honor? A general idea?
You're going to have to talk to our community corrections office about that. It's probably
sounds
less.
Like hundreds of dollars.
Well, I think there's an initial setup cost and then there's a monthly fee, but you know, it is what it is. You know, you're the one that went out and here you had double the legal limit and you're not even supposed to be consuming alcohol. We're all set for today. Make sure you get yourself turned in, or you can make this manageable situation completely unmanageable. So that's it for today.
All right, thank you, Your Honor.
Yeah. All right, let's go on to
That's the next one.
Kenneth Peasy. So well, let's see. Mr. Warden is here on behalf of Mr. Peasy, and that's file 211563ST. And this is the date for a plea. So is that what your client still wishes to do, Mr. Warden?
It is, Your Honor. The plea will be to count 2, operating while intoxicated. Count 1 would be dismissed, and Mr. Pease would like to go forward with that.
Okay. Mr. Chamberlain, is that an accurate statement of the plea agreement?
Yes, Your Honor. Thank you.
All right. And most importantly, Mr. Is it Pease or Peasy?
Pease.
Pease. Okay, I'm sorry I mispronounced it earlier.
That's right.
Okay. Is that your understanding of the plea agreement as well?
Yes.
Okay. Has anything else been promised to you to get you to plead guilty other than dismissal of the count 2? Or have you been threatened, forced, or coerced in any way to get you to plead guilty?
No.
Or I'm sorry, it was dismissal of count 1, plead to count 2. Is that what it is?
Yes, Your Honor. Plead to count 2, the OW, the attempted flee and elude would be dismissed.
Okay. So do you understand that by pleading guilty, you will have a conviction for operating while intoxicated, and that carries a maximum penalty of up to 93 days in jail?
Yes.
Has Mr. Warden answered all your questions to your satisfaction?
Yes.
I need to go over your trial rights with you and make sure you understand those before I'm able to accept a plea, so please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt by the prosecutor, and you have the right to a jury trial to make that determination. Do you understand all those rights?
Yes.
You also have the right to have the witnesses against you appear at a trial, to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand that?
Yes.
In addition, you have the right to testify at a trial, or if you choose, to remain silent, and that silence cannot be used against you in any way. Do you understand that?
Yes.
Finally, by pleading guilty, you give up the right to appeal that you would have if you went to trial. And any appeal of your conviction or sentence would be by leave, not by right, meaning it'd be up to the appeals court whether to even hear your case. Do you understand that?
Yes.
And keeping all those rights in mind, do you wish to waive them all in order to enter a plea to count 2 of the complaint?
Yes.
All right, then. So is it true that on April 22nd, you were driving your car on East Duck Lake Road in Suttons Bay Township in Leelanau County when you were encountered by a police officer?
Yes.
And is it also true you had been consuming alcohol prior to that?
Yes.
Let's see. Was there a test given to indicate what your alcohol level was?
Data master was 0.15.
Okay, and so is that consistent with the amount of alcohol you consumed that evening? You had quite a bit in a short amount of time, Mr. Pease?
Yes.
And would you also agree that due to the consumption of alcohol, your ability to operate a motor vehicle in a normal manner was substantially affected?
Yes.
All right, then to the charge in count 2, operating while intoxicated. How do you plead?
Guilty.
All right, I will accept your plea. I find it's voluntary, accurate, and understanding. The original count 1 will be dismissed at the time of your sentencing, and that will be on?
I think the 30th of July, if that works for Mr. Warden. Although I know that there's an assessment. That paperwork that I gave you was an assessment.
Okay. Well, I'm not going to sentence today because of the, I think I need to know more about what happened, so.
Okay, so July 30th, if that works.
It does.
Okay, so July 30th, we'll be back here. What day, what time?
I'm looking right now. 9 a.m. if that works.
Yes.
Okay, 9 a.m. And prior to that time, I need to get a pre-sentence investigation report done. I have the assessment already. And you'll need to contact the probation office at 922-6899 between 1 and 4 p.m. this afternoon, okay?
Yes, Your Honor.
Okay, is there anything else we need to take up at this time?
No, Your Honor. Thank you.
Thank you.
All right, thank you. All right, I have a competency hearing on Avery Schaub.
Where's your orders on both cases?
And is Mr. Schaub present? Let's see, Mr. Warden, are you still there? All right, we'll come back to that one. So
I'm here, Your Honor.
Mr. Okay, so are you prepared to go forward with the competency hearing on Avery Schaub? You're muted, Mr. Warden.
Sorry, Your Honor. I am prepared to go forward. I was prepared to stipulate to the admission of the competency report from the Forensic Center for purposes of this hearing only. So that should resolve the hearing.
Okay, is this Mr. Schaub maybe on the iPhone?
I believe he's in jail, Your Honor.
Mr. Schaub is in jail, Your Honor. He's in the blue shirt.
Oh, yeah.
Oh, that's Mr. Schaub. Okay, so yeah, thank you, officer. Could you please unmute that? We're still muted. Is the officer still there? Yeah, I can see his hand. All right. Oh, there we go. Okay, Mr. Schaub, are you able to hear everything? Yes, thank you, officer.
Yes.
All right. Mr. Schaub, are you able to hear everything that's being said right now?
Yes, can you hear me?
Yes, loud and clear.
Good.
Okay, thank you. All right, so this is People versus Avery Schaub, file 211-497-FY, and Mr. Warden is here on the defendant's behalf, Mr. Hubble for the prosecutor, and this is the date for a competency hearing. Mr. Warden has indicated that he is accepting the report of the Forensic Center and or moving for it, not objecting to its admission for purposes of this hearing. And so let's see. Is there anything else that we need to take up, or I guess I'll enter a finding that.
No, Your Honor. Typically, when the parties stipulate to the admission of this report for competency hearing purposes only, the court almost always goes along with the finding absent contrary evidence. And then both of these matters will need to be reset for preliminary examination. I would ask that they be set in the afternoon because they are both likely to go and they're both likely to take a couple of hours.
And set on the same date, Mr. Warden?
We had them set on the same date the last time. I think Mr. Hubble and I are okay with that.
All right, so the report having been reviewed by this court, the defendant is competent to stand trial, and Ms. Odom will pick a date for the preliminary examinations.
Okay, either the afternoon of the 16th or the 30th. I think you already have something on the 30th, so.
Yeah, the 30th would be better.
I would note, Your Honor, there are two files. You called one case that there are two, so there are two competency reports.
I'm sorry. We're also here in file 211503FY. The report applies to both cases. I have signed the order in both cases, finding the defendant competent to stand trial.
So that's 1:30 on July 30th.
Okay.
All right. So we're all set then for today, Mr. Schaub. We'll be back on that date and at that time for your hearing in these cases. Is there anything else we need to take up at this time, Mr. Warden or Mr. Hubble?
Not for today, Your Honor. Thank you.
No, thank you, Your
Okay,
Honor.
thank you. All right, and Mr. Schaub, if you could just let the corrections staff know you're all set for this morning, okay?
All right, thank you.
Yep. All right, Mr. Burdette is here this morning on file 211503FY representing Kenneth Gilbert. And let's see. I believe Mr. Chamberlain is still here for the people. There he is, okay. And let's see, where is Mr. Gilbert? Am I just not seeing him? He's not in the jail, is he?
You're muted, Mr. Burdette.
He's in the Grand Traverse County Jail.
Okay, so we're going to need to get the jail on the line here.
Ms. Casties, are you going to take care of that, or should I ask Ms. Schaub here in our court?
I'll take care of it.
Thank you.
All right.
All right, well, while Ms. Casties is getting the jail on the line, I'm going to go ahead to the, let's see, landlord-tenant matter. Let's see, is Mr. Gann here?
Actually, that one's been taken off the docket.
Oh, it
The
has.
only LT case we have is with Mr. Lynch, and that's Inez Schmidt.
Okay. All right, so this is Inez Schmidt versus Kevin Klein and all other occupants. Mr. Lynch is here on behalf of Ms. Schmidt. And is Kevin Klein or any other occupant of 10613 Waterford Street, Unit A, present?
Yes, Your Honor. Kevin Klim's here.
Who is that? You're Mr. Clem or Klein?
Clem.
Clem. Okay, sorry if I mispronounced that. And let's see, Mr. Lynch, have you spoken with Mr. Clem about this matter?
Morning, Your Honor. Yes, I've had the opportunity to speak to Mr. Clem. It's my understanding that as of 9 o'clock this morning, he's indicated to my office that he has vacated and surrendered the occupancy of the premises and returned the keys into the garage. We, given the time constraints between 9 a.m. and obviously this hearing, we've not been able to verify that. My suggestion would be to simply seek an adjournment for 2 weeks to the next hearing date, in which case we can verify he's out. My agreement with Mr. Klein was that this matter would just simply be dismissed and the case would be closed upon verification that possession has been returned to my client.
Okay, Mr. Clem, does that sound like a fair resolution for today anyway? The case would be adjourned for 2 weeks. And
yes.
Okay, and you have vacated the premises?
I have vacated the premises, sir.
Okay. The advantage to an outright dismissal is there's no record that you would have of being evicted, formally evicted, and that could hurt you as far as getting other housing. So anyhow, that's what we'll do is we'll adjourn it for 2 weeks. And if you have moved out and Ms. Schmidt's able to verify that, I'd expect a dismissal from Mr. Lynch. And let's see, what's the next
The
date?
16th, Your Honor.
The 16th, okay. And just in case things go awry, we'll be back here on July 16th at what time?
I guess same time as today.
Okay, same time as today, 10 a.m.
10:30.
Oh, 10:30, okay. And again, if there's a dismissal, you won't need to appear, but just in case things don't go the way they're expected to, then we need to be back here at that time, ready to present a case. And that means you might want to consult with an attorney as well. You do have a right to be represented by an attorney if you so choose. And that's it for today.
Thank you, Your Honor.
All right, thank you, Mr. Lynch, and thank you, Mr. Clem.
Cooney, could you hear me?
Let's see, who was that?
That was Dave Becker, Your Honor.
Oh,
I had a
good morning, Mr.
10:05
Becker.
Yeah, I have a 10:05 final conference, and I'm running into my next Zoom hearing shortly.
Oh, okay. Okay, so that's the final conference.
What's this?
All right, this is file 201433 SM People versus David Becker. Is this the David Becker that I am so familiar with?
It is, Your Honor.
Okay. All right. And let's see, Mr. Donaldson is here on behalf of the people. This is a final conference in this case. And let's see, has there been any resolution, Mr. Donaldson or Mr. Becker?
Next time I talked to Doug, or last time Doug called me, he was going to offer a civil infraction. And the paperwork never followed up from that to resolve it. So I asked Doug again.
I do see a pretrial sheet here, Your Honor, where I did indicate that a civil infraction would be sufficient.
Okay, what's the civil infraction?
It's a general civil under the DNR code. I believe Ms. Casties would have the site for that, Your Honor.
All right, Ms. Casties, do you have a site for that and what the standard fines and costs are?
You have to use this, okay?
Who is this?
Oh, she's probably getting the jail on the line right now. So, Mr. Becker, do you want to accept that offer?
Yeah, I had indicated to Mr. Donaldson.
Jeez, I look crusty. Okay.
Okay, so give me just a minute. I want to get Ms. Casties on the line here. Ms. Casties, can you hear me?
Yes, Your Honor, I can.
All right, Mr. Donaldson's hoping you've got the civil infraction for the general DNR violation in the Becker case and standard fines and costs.
Okay, that would be R 299.922. And standard
What are
cost
the-
generally around $200.
How much?
How much?
200.
$200.
costs.
All right, so Mr. Becker, that's what you want to do is admit to the civil infraction, the criminal charge would be dismissed.
Yes, yeah, that's my preference.
All right, so what did you do?
Well, Your Honor, so you understand, I've got a garden right there on my small lot. And I've got corn in the garden. The raccoons were decimating the corn. So I set out some traps to trap the raccoons. And that Saturday, Saturday night, Sunday morning, a raccoon got into the trap, and I wasn't there that day. But the trap was untagged. I had no idea setting a trap on my garden, on my property, required a tagged trap. But the trapping, just so you understand, the trapping of coons was lawful. I mean, coons are a nuisance creature and you are allowed to trap them. It's just that.
So it's the fact you didn't have the tag on the trap that makes the difference.
That's it.
Okay. Well, I learned something today as well.
Well, I've
All
got
right.
some tagged traps if you need one.
Okay. Mr. Donaldson, is there anything you want to say before I impose fines and costs?
No, Your Honor.
Okay. Anything else you want to say, Mr. Becker?
Just that there's absolutely no intent to violate any law here.
Okay. You are pleading responsible, though, to a violation of Rule 299.922 of the DNR code.
Yes.
Okay. So I will accept the plea, and the criminal charge is dismissed, and I am going to impose the standard fine of $200, although it seems a bit steep given that it does seem a bit steep given that what Mr. Becker did is, was on his own property, nuisance animals, and the fact that, frankly, this court was not aware about the tag requirement, but I'm not a trapper. Well, anyway, I am going to impose the standard fine, and I guess Mr. Becker will need to research the law a little more next time he's got critters on his property and needs to take care of them. So. Okay, we're all set for today. Thank you, Mr. Becker.
Could I ask you something?
Yeah.
Ms. Cassidy is letting me know that we have Ms. Bermudez signed on from Ottawa Jail, and they're going in lockdown soon, and wondered if at 11 a.m., gosh, in a couple minutes, could we take this case ASAP?
Okay, so is Ms. Bermudez present?
Hey, David Becker, I'm gone. Thank you.
Oh, thank you. Cassandra Bermudez, is that possibly you in the, it says Sergeant David Colvin, but you sure don't look like Sergeant David Colvin.
You're muted, Mr. Bermudez.
There, now can you guys hear me?
Okay, yes, now I can hear you just fine. I'm gonna take this case up because I've been told that the Ottawa County Jail is going into a lockdown at 11 a.m. So we're gonna try to get this done quickly, I guess, but fairly. So we'll take what time we need. This is a bond violation hearing. Give me a minute. Well, Ms. Casties, what is the bond violation?
You have her paperwork right in front of you. Nope, you just set the documents right on top of there. Read that.
Oh, okay. All right. Well, I do have a sheet here from Ms. Casties. It says that Ms. Bermudez failed to appear for a daily preliminary breath test at New Directions since April 15th. Let's see, on May 7th, she was arraigned and she wished to plead to the violation. So is that still true? Ms. Bermudez, you want to waive your right to a hearing and admit to the violation?
Yes, Your Honor.
Okay. And so why did you fail to test since April 15th?
I was sick at the time. I was at home in bed, just laying there, and
all right.
Didn't have
because you knew you could go to jail by not testing, you got right on the phone to Ms. Casties and you let her know that you were sick, right?
No, I
Gave her a
didn't.
doctor's excuse. You didn't do that?
No, I didn't, Your Honor.
Okay, well, see, now you might have stayed out of trouble here had you done all that. And that way we could verify you were really sick, but that's hard to do when you don't let us know. Why are you in the Ottawa County Jail?
For fleeing and eluding.
Okay, and you were sentenced to a year in jail.
Yes.
Okay. With credit for 22 days. So given those facts, let's see, do you have an attorney for your case?
For this case?
Yes.
No, I don't.
All right. Well, you may want to talk to Mr. Donaldson about possible resolution of this case.
Your Honor, the matter is scheduled for a pretrial today. I was unable to contact Ms. Bermudez due to her current residency status in the Ottawa County Jail.
Okay. Would it make sense to put you in a breakout room?
I'd be happy to do that, Your Honor.
Okay, so I'm going to give you a chance to talk to the prosecutor about the case. And given the fact you're locked up for almost a year here, he might have some thoughts about what he wants to do with the case. So give me just a second. Okay.
Has Your Honor offered her, have you offered her a right to counsel in this case before she speaks to me?
Oh, well, Ms. Bermudez, oh, too late. She accepted the invitation. Ms. Casty, she would have been told of her right to an attorney in this case at her arraignment, correct?
That is correct, Your Honor. She was told.
Okay. Before I accept any plea, I would confirm that she wants to go ahead with without an attorney, and that she has a right to an attorney at court expense if need be. So if she wants to do that.
Understood, Your Honor. Thank you.
Okay. All right.
Yep.
Thank you. All right. So let's go back to the Gilbert case. And Mr. Burdett, I appreciate your patience this morning. I know you've been on for quite a while here. So is that Mr. Gilbert in the Grand Traverse County Jail there? Thank you. Can you say something just to make sure that I can hear you okay?
It's Scotty.
Okay, I heard you just fine. Thank you. This is People versus Kenneth Gilbert, file 211501FY. Mr. Burdett is here on the defendant's behalf, Ms. Chamberlain for the people. So this is the date set for a plea. And is that what Mr. Gilbert still wishes to do then, Mr. Burdett?
Yes, Your Honor. We had an agreement with the prosecuting attorney that Mr. Gilbert will be was originally charged with the 2-year high court misdemeanor offense of resisting obstruction of police officer, and the 93-day operating while impaired offense, and enter into a plea agreement where he will be entering a plea of attempted resisting obstruction of police officer and impaired driving. The attempted is a 1-year misdemeanor.
Okay. Is that a correct statement of the plea agreement, Mr. Chamberlain?
I believe so, Your Honor.
Hang on just 1 minute here. All right, so the offer then is to an attempted resistant obstructive police officer and impaired driving. Correct, Mr. Burdette?
Yes, sir.
All right, and Mr. Gilbert, is that your understanding of the plea agreement as well? You'd be pleading to a reduced charge of attempted resistant obstruct. That makes the 2-year felony a 1-year misdemeanor and also an impaired driving.
Yes.
Has anything else been promised to you to get you to plead guilty, or have you been threatened, forced, or coerced in any way to get you to plead guilty?
No.
Has Mr. Burdette answered all your questions to your satisfaction?
Yes.
I need to go over your trial rights with you and make sure you understand those before I'm able to accept a plea. So listen carefully. You have the right to be tried by a jury, to be presumed innocent unless and until proven guilty beyond a reasonable doubt by the prosecutor. You understand that?
Yes.
You also have the right to have the witnesses against you appear at trial, to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand that?
Yes.
In addition, you have the right to testify at a trial, or if you choose, to remain silent, and that silence cannot be used against you in any way. Do you understand that?
Yes.
Finally, by pleading guilty, you give up the right to appeal you'd have if you went to trial, and any appeal from your conviction or sentence would be by leave, not by right, meaning it would be up to the appeals court whether to even hear your case. Do you understand that right?
Yes.
And do you wish to waive all those rights in order to plead guilty?
Yes.
All right, then. Is it true then that on, let's see, December 12th, 2020, you were at an address in Suttons Bay Township, Leelanau County, when you were encountered by Officer Isaac Burfield of the Grand Traverse Band of Tribal Police, and you had some kind of incident there where he arrested you. Is that correct?
Yeah, somebody hit me in the head and crashed my car.
Okay. Well, what were you doing that got Officer Burfield's attention?
Somebody hit me in the head and crashed my car into a ditch.
All right. So, Mr. Burdette, I'm lost here a little bit. Can you help me out with the voir dire?
Yes, Your Honor. Mr. Gilbert, you indicated that somebody hit you in the head. You know, where you were driving a motor vehicle. Is that correct?
Yeah.
And when you were driving that motor vehicle, I guess that incident happened in the motor vehicle, causing the vehicle to crash.
Can you repeat that, please?
While you were driving the vehicle, did someone cause you to crash the vehicle? Did they grab the wheel or something like that?
Yes, he reached from the back, he grabbed the wheel. There's 2 females in the car, 2 witnesses, and yeah, he reached over, grabbed the wheel, swung me in one part of traffic, swung me into another, and I tried hitting the brake, tried to straighten it out, and we went into the ditch.
Okay. And when you're in the ditch, did the police arrive at some point?
Yeah, about 5 minutes later.
Okay. And did they have you do? Did they? Well, and speaking with you, did they have you do some field sobriety tests?
Yeah, passed them. Then I started telling them what was going on, and I just got mad because he wouldn't listen because they fled down the road, and well, he kind of scared me because there's news reports of like people dressing up like cops and acting like it. Then I got scared because I didn't know what was going on because my head hurt. He ended up hitting me in the head several times with a phone while I was driving and while I was sitting. I just kept getting more and more mad about that. And he had the fat lady and the one dude end up just fleeing down the road while he's sitting here telling me, "Oh, don't worry about that." It's like I could have a concussion right now. I have mental issues and I have like brain damage, and getting hit in the head is not good for me.
And I know you're homeless as well. Is that correct?
Yeah, that too. Majorly. I'm more concerned about my health, but I know like nobody else is.
Well, Mr. Gilbert, did there come a time where the officers tried to arrest you and you resisted the arrest?
Yeah, I got scared. I got mental problems that caused me to like basically black out, forget what I'm doing, and just want to get away from the situation. It's just something that takes over me. I got schizophrenia, PTSD, ADHD, ADD, OCD. I got dyslexia, insane. I got I believe autism too now, and I got Tourette's.
Okay. And when they arrested you, I mean, you would say that you weren't following their direction, their orders and what they wanted you to do, and struggled with the police. Is that correct?
Oh, I did what they want for the most part, but the minute they kept telling me that they won't go get or even call back up for down the road, I just kind of quit. I sat in the car. I just refused to get out because I felt scared.
Okay. And they wanted you to Pardon?
I said I just had a huge tragedy happen. The cops looking at me dumbfounded. I'd ask him if he could like not let somebody who assaulted me with a phone and who almost caused us all to die. And he's just looking at me like, I don't give a shit. I'm here to fucking bother you. I don't care if you lose your tooth, your health, your brain, or even killed everyone in the car. As long as you ain't dead, you're going to jail if I can help it. So that made me think he wasn't a real cop.
Okay.
Usually, cops are supposed to protect the land, not sit here and just harass something that's just in a ditch.
Okay. And Mr. Gilbert, they wanted you to do a chemical test, and you refused that?
Oh yeah, until he went and actually addressed the problem. I don't care if you can't do your job, and this is more important. Like I said, it's just on me, I suppose.
Okay.
He could be going down and harassing a whole farm full of people down there, and be like, I didn't know. Nobody called.
Okay. Well, did you have anything to drink that day while you were driving?
No.
Or you're driving?
I mean, the only thing I had was probably I was a morning drinker that day, but that's about it.
Okay. And did you smoke some marijuana that day too?
No, I
operated the car?
No, the lady next to me is a patient.
All right, because we had some results from Michigan State Police that indicated that.
Blood test.
Yeah, you had you went down to Munson to do a blood test. Is that correct?
Yeah.
Okay. And when it came back with a blood test, came back, Your Honor, with a presence of marijuana and a alcohol of 0.043, and the allegations are that he was impaired due to the consumption of the combination of both.
All right. Well, is your Mr. Gilbert, are you contesting whether those test results were accurate?
Oh, I don't know how long it stays in your bloodstream. I just know I drank quite a bit that morning, so I just know I wasn't like, I was driving perfectly fine. I was stable and everything, but like I said, nothing, it was just getting hit in the head is what caused me. So I can't really say if it is or isn't. I don't know how long it stays in your system. I know marijuana stays in your system for a month or more. Depends on how much you smoke. So I can't really say. I'm not going to testify.
Well, let me ask you this. based on what you had to drink that morning and the marijuana, do you think that your ability to drive a car was visibly impaired, meaning another driver might have noticed that your driving was off because of the consumption of alcohol and or the marijuana?
I'm gonna say no.
Okay, well, I'm not going to accept the plea then today. The defendant has not admitted to facts that would establish an impaired driving. So let's see. We'll set this for a preliminary examination at a later date.
Your Honor, if we could, this is a remand for the circuit court. If we could just schedule this for another plea date and give me a.
All right, well, so Mr. Burdett is hopeful that maybe this will be, maybe that we can fix this plea or something, but I don't know. The defendant was pretty clear. Defendant was pretty clear that he wasn't impaired or intoxicated. So anyhow, we will give Mr. Burdett another opportunity to speak with his client. And how long do you think you need? My next Sutton's Bay Day, 2 weeks?
16th.
The 16th. Is that going to work?
Yes, Your Honor. I mean, I was wondering if I could speak with my client, if we could do it maybe Grand Traverse next week. I mean, he's in jail right now, and I don't want him to sit in jail any longer than he has.
Oh, well, that's no fair.
I'd have no objection if they want to meet in the breakout room.
Okay, well, I think it was.
Judges, he's been in and out of jail on bond violations and failure to appear issues, and he's served a fair amount of time on this already.
Okay, well, I think it would be better though to give Mr. Burdett some time to sit down with his client and hash this out. So we'll put it on a Grand Traverse Day, but let's make sure we'll have a Leelanau prosecutor available for that. So go ahead and set that, Ms. Odom.
And I might just let everyone know that in this case, he's on a PR bond that I can tell. I don't know if he's a remand from circuit court, so I really don't know what bond he's on, but our case, he's got a PR. So he's not getting credit is what I'm trying to tell you for the time he's sitting.
Okay, he was arrested at a bond violation. The judge remanded him to jail. So at this time, we're just requesting the court cancel the bond. If it was
all right, we'll cancel the bond, and we'll figure that out at a later date. So, all right, did you pick a date then?
No, I am right now.
Okay.
All right. So next week we're looking. Okay, so how about Friday the 9th at 9:45?
Yeah. I think
okay, so Mr. Donaldson, you'll make someone available from your office on that date?
Yes, Your Honor.
Okay, great. All right, then we're all set for today unless there's anything else for you, Mr. Burdett?
We had a waiver of a preliminary examination for Mr. Core.
Ah, okay. Let's see. And where is Mr. Core? Is he in the jail? He's on bond. Oh, he's not. Okay. So we're all set then for today, Mr. Gilbert, and we need to get Joshua Core now.
Okay.
All right.
Well, he's out on bond. Let me.
Oh, he is on bond.
Yeah,
we don't have.
Okay, thank you, officer. We're all set.
Okay, so you know what?
What did I say?
Let's wonder, Your Honor, if could we schedule his preliminary exam waiver for next week in Leelanau County? I have 11:30 Circuit Court Settlement Conference.
Well, I'm just wondering why he's not here this morning.
Yeah, let me see what I can. Let me try to call him.
Okay. So we'll give you a chance to do that, and we'll go back to the Bermudez case. Although now I don't see Ms. Bermudez. They must have their lockdown going. Nope, there she is. Okay. All right. So, Mr. Donaldson, were you able to work anything out with Ms. Bermudez?
Yes, Your Honor. Ms. Bermudez is agreeing to enter a plea to the assault and battery charge and to pay restitution on the MDOP charge, but that would be dismissed.
Okay, is that a correct statement of the plea agreement, Ms. Bermudez?
Yes, Your Honor.
Now, I want to make sure that you understand you do have a right to an attorney, and the court would appoint one at public expense if that's what you wanted to do, okay, and you qualify, and I'm sure you would because you're in jail right now. Are you waiving your right to an attorney?
Yeah.
Okay. And let's see, has anyone promised you anything else to get you to plead guilty, or have you been threatened, forced, or coerced in any way to get you to plead guilty?
No, Your Honor.
Are they done with you?
All right.
You're about to miss lunch.
Okay, I'm almost done.
Okay.
Mr. Donaldson, again, what is the plea offer?
A plea to count 2 an assault and battery against Mr. Juan Bermudez on April 14th of this year.
Okay. And do you understand that by pleading guilty, you will have a conviction for assault and battery, and that carries a maximum penalty of up to 93 days in jail?
Yeah.
And you've also agreed you'd pay the restitution for any damage to property that you caused?
Yes, Your Honor.
All right. I need to go over your trial rights with you and make sure you understand those before I'm able to accept a plea. So please listen carefully. You have the right to a jury trial, and you have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt by the prosecutor. Do you understand that?
Yes, Your Honor.
You also have the right to have the witnesses against you appear at trial, to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand that?
Yeah.
You also have the right to testify at a trial, or if you choose to remain silent, and that silence cannot be used against you in any way. Do you understand that?
Yeah.
And finally, by pleading guilty, you have you give up the right to appeal you'd have if you went to trial, and any appeal would be by leave, not by right, meaning it'd be up to the appeals court whether to even hear your case. Do you understand that?
Yeah.
So, knowing all those rights, do you wish to waive them in order to plead guilty to the reduced charges?
Yes, Your Honor.
All right. So is it true that on April 14th, you were at a location in Leelanau County with Juan Bermudez, and that you committed an assault on him?
Assault and battery, right?
Assault and battery, yeah.
Yes.
Okay, who's Juan Bermudez?
That is my dad.
Oh, okay. So what was the assault?
I just threatened to stab him with a fork, but I didn't do it. I just scared him, so he called the cops.
Okay. All right. So did you have the fork aimed at him in such a way that he would have felt threatened, like you were going to stab him with it?
Not really close to him, but like, I mean, I scared him enough for him to call the cops, so yeah.
So would you agree he was concerned that you might stab him with that fork?
I mean, I've never done anything like that before in the past. That's my dad. I wouldn't have stabbed him. I was just trying to scare him. So
Yeah, but that's what's in your head, but you were trying to scare him. And from his perspective, do you think he might have felt like he might, you just might follow through with that? Stab him with the fork?
Yeah, sad to say.
Okay. All right. Well, then to the charge of assault and battery, then how do you plead?
I plead guilty.
Okay, I'll accept your plea, find it's voluntary, accurate, and understanding. The malicious destruction of property will be dismissed at the time of your sentencing. I will need to set a sentencing date on this since there's a victim. Your father has a right to test or make a statement at that sentencing and get notified of the hearing. So, Ms. Odom, you want to set that up?
Yeah, sure. So July 30th.
Can I say something?
Yeah, go ahead.
I have a review here on the 27th to get released on intensive super probation program here in Ottawa County. I was just gonna ask if that could be beforehand so I could get maybe I could get this lifted so I can go to treatment.
Okay, yeah, I don't think that should be a problem. So let's try to do it a few days before that.
Oh, we
So-
can do it the 16th.
Okay, we'll be back on the 16th of July.
At, hang on here.
I do want to get a pre-sentence investigation report.
Okay.
And the probation office will contact you there at the Ottawa County Jail. And they'll want to interview you, find out more about the incident from your perspective, okay?
All right.
All right.
So she's also not accruing time on this Leelanau case that I can tell.
Okay, we're going to go ahead and cancel your bond in this case. What that means is you'll be getting time from today on. So that's, if you had an attorney, that's what they would recommend. And that way you'll get credit, okay?
Okay.
All right. Okay, we're all set then for today, and you can let the correction staff there know that you're all set, all right?
All right. Thank you, guys.
Yeah, thank you.
Where were we? What happened to Mr. Kohler? Anything? Or I mean, Mr. Morales?
I don't think he showed up. So let's go back to People versus Joshua Core, Mr. Burdette. Any luck?
I called him and, I talked to him yesterday. He wanted Zoom instructions. I sent those to him. I called him and left a message. I told him he had to come in today. He's been, just to do the waiver, because we talked about that and what it meant, and he was agreeable to do it. I don't know why he's not here. He's always been contacting me. I was wondering if the court would agree just to adjourn it so we can waive it next Friday.
All right. Maybe Miss Casties, if you're there, you could enlighten me whether we've had any previous fail to appears on Mr. Core or any bond violations.
Yes, Your Honor, I'll take a quick look here.
Okay, and while you're doing that, Mr. Donaldson, what's your position?
I have no comment, Your Honor. I'd leave the court to its discretion.
All right.
The only thing, Your Honor, that he had was a miss on a drug screen because he didn't have any money, but he did take it as soon as he had money a day later. So that's the only thing I see on here.
Okay, then I am going to give Mr. Burdette an adjournment here. You want to set a new date, Ms. Odom? It sounds like the defendant has been cooperative in working the case with his attorney. He's been testing, and so I'm going to assume there was some mistake made this morning about being here or what time. So
July 16th at 11?
Yeah, that's fine.
okay, anything else on that case?
Nothing, Your Honor.
Okay.
Nothing, Your Honor.
Thank you. All right, thank you, Mr. Burdette, and again, thanks for your patience this morning.
Oh, that's no problem.
I'm going to call the case People versus Aiden Morales, file 173179ST. And oh my goodness, we have the whole Leelanau County Prosecutor's Office on the line, but unfortunately, no Mr. Morales. So anyhow, are you asking for a bench warrant for Mr. Morales, Mr. Hubble, Mr. Donaldson, Mr. Chamberlain?
This is my
Suspended
case.
license.
This is a DWLS second. There was a failure to appear back in 2017. I'm not exactly sure why he came back in April. We spoke with him, and in May, he missed his status conference. Later in May, we had a final, or the final conference was set, but I don't recall whether or not we spoke to him that day. I honestly have no preference one way or another for a.
All right. Well, I'm thinking that this is a 2017 case. We really need to get it resolved. So I'm just going to issue a bench warrant. There'll be no bond. And we'll see if we can catch up to Mr. Morales. Well, I think we're all set then for today. And I hope you all have a terrific 4th of July weekend.
Your Honor, I think we have one more matter.
Oh, no. Okay.
I don't have anything else on my docket, though.
All right.
I have a dispo.
What's this case? I don't know.
I'm here for Bradley Gay. I believe that's who Mr. Hubble's here for too. I did notice it was already noted on the calendar that Mr. Gay failed to appear, probably because he did not turn himself in, from what I hear, for the 5 days that the court had ordered 2 weeks ago.
So it's no surprise he's not here today then either.
That is correct.
I don't have it on the docket, though.
All right. Well, so he was already sentenced to 5 days. So I guess what I'd be doing is just issuing a bench warrant for his failure to appear. Or has that already been done?
I guess maybe that's already been done, and that's why this is not popping up as a
okay
thing. I'm not sure though.
All right, so when we catch up to him, I'll want to have a show cause hearing to determine if he should be held in contempt of court and maybe additional jail time imposed. Okay.
That's fine, Your Honor, because what Mr. Travis and I were anticipating today was a preliminary examination which had been adjourned from a previous date. So it makes sense we need to get a hold of Mr. Gay one way or the other before we can decide how we're going to proceed.
Okay, so there'll be no bond if there was a bond set, Ms. Casty, so bond is canceled.
Right, yes, sir. It's a no bond bench warrant.
Okay.
Already been issued.
It is, okay.
Yes.
All right, well, good then. Anything else on that case, Mr. Travis?
Nothing further from me.
Okay, Mr. Hubble?
No, thank you, Judge.
All right, now go forth and have a great weekend.
Thank you too.
Thank you for the blessing.
Oh, that was funny.
Signed all these?
Oh, I guess I better sign it off here too. All right, thanks for all your help this morning, Noreen.
Thanks, Noreen. Oh, and I've got Gay covered.